Welcome to Sakshi TV's special immigration show with attorney Ms. Sheela Murthy from Murthy Law Firm. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheela Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with Bhanu Ilindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Murthy needs no introduction, but if you need consultation, please log on to murthy.com for contact information. From the beginning, murthy.com has put a wealth of free online information in the hands of immigrant community and for the benefit of US employers. The murthy.com site provides you with the latest and cutting-edge information on US immigration law and policies, explained in terms you don't have to be a lawyer to understand. Today's topic is latest immigration updates, CR1 and Form I-751. We will continue the knowledge session along with the Q&A. And before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask tips. Hello, Ms. Murthy.
Hi, good afternoon. Great to see you, and you're doing a fine job with the introductions.
So much. Good afternoon to you too. Before we get on to the topic, do we have any latest immigration updates this week, Ms. Murthy?
So there's nothing earth-shattering. I know people are very anxious about the premium processing program options for EADs, but there's nothing that's come out finally. Canadians, of course, still have the TN option, and Canada is planning to open up this week to people who want to travel. So if you can spend, potentially as an Indian national, one could spend 14 days in Canada if you're doing international travel, though as Indian nationals and Indian citizens, there are additional burdens from Morocco and India where you need to show a COVID-free test in addition to full vaccination. So there's minor issues that affect people who are doing international travel. We're hoping for the premium processing upgrades to expand, but we're waiting for the final rules. And I know Department of State, Charlie Oppenheim, expects a lot of forward movement in the priority dates and visa numbers to continue during the fiscal year. Already we have seen the dates for October of 2021, but we're hoping in the middle of September we'll get it, for October, and we expect some movement to continue in EB2 and EB3 for India. So there's been no other earth-shattering change or development.
Right. What is the new rule for Immigration 2021?
What is the new rule for Immigration 2021?
Yeah, are there any separate specific rules that we need to be updated with for Immigration 2021?
Well, so obviously in 2021, we had President Joseph R. Biden become the president of the country. And so there's been a change and shift in the philosophical and ideological way in which immigration is generally viewed in the country. There's a more openness to employment-based immigration, to reuniting families, to being open to people who are being persecuted because of their race, religion, and one of the protected categories as for asylee and refugee status. But in terms of actually the changes happening, as with all bureaucracies, it's a slow moving process. It's a bureaucracy, not as bad as maybe some other countries, but still there's a layer of bureaucracy that we need to deal with. And it takes a while because we have to change processes and systems with one of the largest agencies that is undertaking immigration law. So there's been no other earth-shattering change other than what we've just discussed and what we've been discussing every week with each of you.
Right. Ms. Murthy, how can one extend their conditional permanent resident status?
So I think you already referred to it. You filed the 751, and if you've already filed it, and USCIS used to previously approve it within 6 months. Then they made it 1 year, so it was valid for 1 year. Now they're planning to extend it from 1 year to 18 months. And maybe even go up to 24 months because they realize that they are not wrapping up or completing the removal of conditions on residency, the forms I-751, based on marriage to a US citizen or a permanent resident. If you get it within the first 2 years of the marriage, then you only get a conditional green card instead of a permanent unconditional green card. So your card, which expires in 2 years, you need to file the form I-751 to remove the conditions on residency, pay the filing fees, and show proof of the bona fides of the marriage and the fact that it is continuing in order to take advantage of the 2-year time frame to remove the conditions on residency. And if it's 3 years from the day that you got your original conditional permanent resident card, 3 months before, you can actually file for US citizenship, even if your conditional resident card has not yet been approved. Many people, including lawyers, don't realize that and get confused with this rule. Thank you.
Right. Ms. Murthy, we have a caller, Mr. Bhanu from Texas. Thank you for calling, Mr. Bhanu. You can directly ask Ms. Murthy your question.
Hi, Murthy ma'am. Good afternoon. Thanks for taking this call. I have a question regarding my scenario, Murthy ma'am. So my H1 got selected with employer A and it got RFP, and we are supposed to submit by end of this month, and my contracting job is about to end by September 28th. So I don't know how it goes, whether like if I submitted RFP, once the case is approved, technically I'll be out of the project. So if I get any full-time offer with different company, can I use that H1, or will it work, or it doesn't work at all?
So Bhanu, if a person gets another contract, then when you're getting the other contract, you would obviously need to file for it ASAP. Now, if this gets approved for this project, technically you're supposed to work in this project unless it's a very short-term intermediate step, because according to the Simeo Solutions case, as you well know, the USCIS expects that the filing should be done prior to starting on the new project in the new work location or with the new employer or new client. It's always touchy and difficult, I think, for consulting companies where the turnover and the change in jobs is so frequent. And sometimes you don't know who your next or which employer or which work location you might be working. So what you could do is continue to work, obviously, end of the month, which is just 3 weeks away. But in the meanwhile, if you get a new project, then hopefully you can file it ASAP. And as long as the petition, the LCA is obtained and the petition is filed prior to the new project starting, that would be great. Or if your new project has started, you would still file it. And if the USCIS issues an RFE asking for status or request for evidence asking for proof of status, best case scenario, they approve the new employer with the I-94 card. Worst case, if they don't approve it, Bhanu, then you would actually be able to work while it's pending. But once it's decided, approved without the I-94 card attached, then the person, you as the beneficiary, is required to travel out of the country. If you have a visa, come back just showing the I-94 or the H-1 approval notice, or if you don't, then you'll have to apply for a visa. And of course, with the presidential proclamation right now that is preventing people from traveling and coming back from India unless you can show a national interest exemption, it could create delays and problems. So getting that I-94 card attached, getting the change of status approved is extremely important. So try really hard to get the project confirmed, and hopefully for the employer to be able to file it with the new project, or if they have in-house work for you in the interim, then let them do that. Good luck, Bhanu. I hope it works out.
Thank you.
Ms. Murthy, what is the processing time for I-751?
So the processing for 751s used to be approximately, as I said, between 6 months to a year, which is why they had kept a maximum 1-year time frame. Right now, the USCIS is taking, it could be even 18 months up to 2 years, which is why they have agreed to issue a receipt notice extending it, the validity for travel and work authorization, for up to 18 months or 2 years. And if you don't already have it, you can print out a copy of the latest change in the notice from the government and take that to the local office to ask for an extension, or contact the USCIS to give you an extension or to give another receipt notice with the new, requesting them to give it, showing that it is automatically extended for that additional time frame.
All right.
Thank you.
And what is the processing time for I-829?
So that is the removal of conditions, not on marriage-based green card, but on the EB-5 investor-based green cards. So again, those are, well, depends. If you're doing it based on the regional center, well, they no longer exist. And the government, we're waiting to get clarification if the government's even going to extend those cases or what's going to happen to it, because the law is technically sunset, no longer allowing EB-5 direct investment, and we don't know what's going to happen. We expect some clarification. We expect the legislature to jump in. But if nothing happens, then that's a bigger problem because that category no longer exists. On the other hand, if it's EB-5 based investment in a direct enterprise or direct investment, as we call it, then the processing, again, has been taking anywhere from, I believe, anywhere from like a year to 2 years or longer. But in the meanwhile, again, you get the conditional, the receipt notice allowing you to stay and keep working based on the I-526 approval, even if the EB-5 extension for removal has not yet been approved.
Right.
Thank you.
So, Ms. Murthy, you have a caller, Mr. Venkat from Detroit. Thank you for calling, Mr. Venkat. You can ask Ms. Murthy your question directly.
Okay. Hi, Murthy ma'am. I have a
Hi,
question.
Venkat.
Hi, I have a question. Like when my green card was processing, when my green card application was filed, my son was below 21. When it is approved, he has crossed 21. So is there anything going on for aged out kids, legal aged out kids like HR6, something like that?
So there's no law right now that's going to, at least that we are aware of, that's likely to pass. As you very well know, Venkat, there is something called CISPA, Child Status Protection Act. So depending on how many months or years your I-140 petition was pending with USCIS, that time frame, let's say it was pending for 8 months, those 8 months you can add back to the age of the child after the child crosses 21, because the I-140 petition pending time, or the I-130 if it's a family-based case, can be credited back so that the child is not considered aged out or over the age of 21 based on the CSPA, the Child Status Protection Act. If you've included that time and you've taken that into account, and now the child, let's say, is 23 or 24, and now you're like, what can I do? Well, hopefully the child had filed a change of status from H4 dependent to F1 to pursue full-time education. And then if the person got the 12 months OPT and then the 2-year extension of the F1 STEM, Science, Technology, Engineering, and Math, STEM optional practical training OPT extension for 2 more years, then during that time, they would be eligible to file for the H-1B change of status, just like most of us were after studying in the US. And then unfortunately, the person would go through the same whole 9 yards, the way the process you went through and I went through when we went through our own immigration processing to get the permanent resident status in the United States or the green card status. Of course, if they get married to a US citizen, they would use that process through family-based, but otherwise Child Status Protection Act has limitations. It looks fairly simple. There are lots of nuances to it. So hopefully you've spoken to a lawyer, consulted with somebody, or talked to your company lawyer if they're helping you with this to see how you can try to protect and ensure that your child is maintaining his or her own valid separate status so that there is no out of status or unlawful presence issues. Good luck, Venkat.
Right. Ms. Murthy, we have another caller online, Mr. Venkat from Carolina. Thank you for calling, Mr. Venkat. You can ask Ms. Murthy your question directly.
Yeah, sure. Yeah, hi. Thank you for connecting me to the lawyer directly. Thank you so much. Hey, this question is for my friend. So who is trying to apply the last year, means 2021 cap, and unfortunately he has applied through 2 consulting companies, and both of them got picked up. Okay, and I just wanted to understand the process. What would happen if he tries to file the petition for both of the companies, or like it is illegal to apply the 2 employees at the same time?
So the regulations are very strict about it. As long as it's 2 completely separate employers, it's not the same underlying project, then it's allowed because it has to be two completely separate jobs. If it's two completely different employers, but the same underlying project or contract, the USCIS by law has to deny both of them and hold both the employer and the employee liable potentially for fraud, which could pretty much end up becoming a lifetime bar. So whether it's for you or your friend, Venkat, it's extremely important. I tell people, don't all try to take shortcuts, because sometimes when we think we're so smart, we could end up being really not so smart and pretty dumb and messing up our life. And the last thing you want is obviously a lifetime bar in a situation like this. And if the friend is truly for a friend, then the friend should be calling for his or her own life and not having you speak on their behalf.
Sure. Okay. I understand.
Thank
Thank
you,
you so
Venkat.
much. Yeah, Ms. Murthy.
So, Ms. Murthy, does
Thank you, Venkat.
Ms. Murthy, does USCIS conduct system maintenance to CRIS, Contact Relationship Interface System?
So when you say system maintenance, I'm not sure. I was just talking about just technologically system maintenance. What exactly are you asking for, requesting?
As in the technological
question.
system maintenance, does it conduct any sort of system maintenance for CRIS?
So USCIS has a whole technology team, and they conduct maintenance all the time on different issues and forms. And sometimes they find out when there are problems because clients, whether it's individuals or employers or families or attorneys, will bring to their attention problems that are occurring with the system. So they certainly expect and appreciate feedback when they make mistakes, like how they had denied a lot of people the H-1B for the quota at the start of the fiscal year 2021, when they approved or they denied many people because they had put a starting date last year of after October 1st, because they filed in the second batch of the registration. They agreed that all of those people are allowed to refile the H1, show proof of the original filing with the receipt notice, with the paperwork, with the package, with everything that they had. And as long as it is received by USCIS before October 1st of 2021, they will then accept that person, that gap subject petition that was incorrectly and improperly rejected, not denied, but rejected from my mailroom because of their misunderstanding of the law. So they have all kinds of systems and processes, and when they realize they made a mistake, they go ahead and try to clean up the mess and try to set up systems and processes to be more fair to the general public that is using their services.
Right.
Thank you.
We have our next caller ready, Mr. Srinivas from Virginia. Thank you for calling, Mr. Srinivas. You can ask Ms. Murthy your question directly.
Yeah, thank you, ma'am, for taking my call. I hope I'm audible. So, hello, ma'am. I applied my EB2 downgrade on 2020 October with receipt date, and my medicals is submitted at the time, and I got my EAD and all that. So it went to Texas Processing Center, and I see today after this Labor Day, there was a processing time earlier. It was shown as 24 to 64 months approximately. Now it came down to at least it came down to maybe around 20 plus months. So I'm just thinking, what is my possibility of getting the card within this year's quota?
Well, so if your priority date is still current and your file is 100% complete, you've submitted your medicals, I-693, and everything looks perfect. I know that they're desperate, Srinivas, to go ahead and approve many of the I-485s because of the huge number of unused visa numbers. So I know that they're asking people to please send them the information ASAP so that they can approve the case. Whether it'll get approved before the 30th of the month and everything is 100% complete with your file, obviously I don't know, I haven't looked at the file. But if it is, they might want to approve it. And they do want to approve cases because they are getting a bad name and they are getting lawsuits filed against them. And they want to make sure that they do the job because there's been an overflow in unused visa numbers for so many years that keep overflowing from year to year to year, that they are very eager to move things along. And as I often complain and say, you know, only the government can do this, where they keep raising the fees, the quality of service keeps going down, and they're rewarded for incompetence in the sense that if they take longer or they hire many more investigators than is required, because there really isn't any kind of fraud on a rampant basis that they are claiming that there is, they're not penalized. If it's a private business, if you and I in private business took as long to process a case or to do work, we would be out of business. We would be worried about what would go wrong. But for some reason, the federal government thinks it can get away with it, and I guess they have, because they are a monopoly to that extent. And as I've often said, most of us might be in jail for doing something fraudulent or illegal, where they keep raising their fees, the quality of service keeps going down. We don't know, there's no end in sight of when something will get resolved, and people are desperate. People lose their salary, their income, their jobs, and the attitude is too bad. There's no attitude to taking care of the customer or client that is essential. And in fact, they removed the term customer or client and the fact that America is a nation of immigrants from their own vision statement or mission statement of the USCIS in the last few years during the prior administration. So how long will it take, Srini? Who knows, right? Because nobody knows 100%, but they are keen to move things along.
Ms. Murthy, we have our next caller ready, Mr. Ravi from North Carolina. Thank you for calling, Mr. Ravi. You can ask Ms. Murthy a question directly.
Hello, ma'am. Thanks for conducting this call. Thanks to Sakshi TV. I have a question. My wife started using the GCEAD, and my attorney withdrawn the pending H4 and H4 EAD applications, and they were successfully withdrawn. And USCIS sent a letter to our home address that the H4 and H4 EAD pending applications are withdrawn successfully. And in that letter, they mentioned my wife will be out of status after the the current I-94 valid date. So my question is, will my wife be protected under the pending 485 application? Currently, she has the GCEAD and advanced parole, and our 485 application is still pending. Everything is completed, but we didn't get the green card so far.
Sure. Did you say Ravi, right? Ravi?
Yes.
So Ravi, so the bottom line is, it's true that a person, if you don't have H1B or H4 status, you are not considered in a period of what's called a valid non-immigrant status or NIV status. And so now all you have in terms of status in the US is what's called pending 485 status or adjustment of status pending status. It's not really a valid non-immigrant status, it's just what's called a POAS, period of authorized stay. The old name used to be called POSABAG, period of stay authorized by the Attorney General, but now it's called POAS. And the issue with, of course, the POAS is, God forbid, for some reason the 485 gets denied, now you have no backup status. What I don't understand in majority of the cases is why, if the H1 was filed and the H4 was filed and it was pending, and if the fees are already paid, why not just let it continue to get processed? Let it be, because that doctrine of dual intent allows both the H1 to be valid and the 485 to be valid, and the person can pick which EAD they want or whichever gets approved first. I'm always concerned when you withdraw it because it confuses USCIS. They don't know if you have been fired from the job or you're quit or you're still there. You don't have full protection, though you are considered in a period of stay. So she's allowed to work, she's allowed to study, she's allowed to stay here in the US legally because of the 485 EAD. But if something goes wrong with the 485, then you have no backup status, Ravi, for you and your family. So
okay,
I'm not sure why they withdrew it, but I'm sure they had their reasons.
Yeah, I'm not sure either. They have withdrawn the application by saying it will be safe to withdraw, and we didn't question anything on that.
Thank you for calling, Mr. Ravi. So, Ms. Murthy, my next question is, how long does it take for an I-30 to be approved, I-130 to be approved?
So the strange thing about all your questions regarding processing times that I'm having is these time frames keep changing all the time. So if something normally used to take 3 to 6 months, right? The I-130 and 485s. Now we know that most of them are taking between a year and 2 years. But that could change in 3 months, 6 months, either because they get more people, more funding, they get their act together, they realize that the prior administration under Trump purposefully abused and misused and abused the system in a manner to take advantage of employers, employees, and families by cashing in checks and refusing to do the work. And so how long does it take? Right now, it's a year to 2 years. It could change. It could become 2 to 3 years. It could hopefully go back to what it used to be. That's our hope, of 3 to 6 months to approve the I-130 and 485. But that's not really a legal issue. That's a very simple procedural issue that your readers or anybody else should be able to find very easily by going to the USCIS website and looking at the particular service center and looking at their processing times for I-130 petitions. Thank you.
Ms. Murthy, what is your golden immigration message to our viewers watching this show today? In these uncertain times, what would your advice be to them?
Well, my advice about immigration, as much as about life, is, you can only do 100% from your side. Maintain a positive attitude. Sure, we'll have wins that give us a hard time, like for sailors often talk about the winds that prevent you from sailing straight in life, but don't let the negative get to you. Think positive, be proactive, be your best advocate and champion to fight for your own life. If your lawyer tells you something, if your employer says something, don't just say yes sir or yes ma'am, like the way we are taught in India to be very respectful and deferential to our elders. You can be respectful and kind, but you can ask questions because God gave us a brain to use that brain to ask questions. So be your own best advocate, be strong and true to yourself, believe in your own case, fight for justice for yourself and for those around you. And I want to wish each of you continued success. And I hope I will have the privilege and the honor of helping you with your immigration case. Please take advantage of all the wonderful free services that we offer through Murthy.com to educate you, to empower you, and to enlighten you through the Murthy.com website, the Murthy.com free weekly Murthy bulletins, the free Murthy forum, the articles we post, the FAQs that we answer. Take advantage of it to educate yourself because knowledge is power, and only you can take care of doing that for yourself.
Right. Thank you, Ms. Murthy, for all the wonderful insights and wealth of information you've shared with us. And for all our viewers, for a private consultation, please log on to Murthy.com for the contact information as well as a private consultation. Thank you, Ms. Murthy. It was a privilege hosting you. You're watching Sakshi Live. This is Tony Makana. Thank you.